most of you, I guess, know me because you're on my page, but I'm Sabine, also known as the Purpose Lawyer, and I run a law firm in out of New York, licensed in New York and New Jersey, but some of my practice areas cover other states because they're federal, so they apply nationally. And so I wanted to come here and just talk to you guys about legacy planning because I just met a lot of people who were kind of taken by situations that could have caused them to have a lot of wealth, but because they didn't know and they didn't know what to do, or their parents didn't know what to do, they kind of lost assets that they could have had that could have made a big difference for them and their families. Let me turn off my AC. So it could have made a big difference for them and their family. So I kind of wanted to share a little bit so you guys have a basis, and if you have any questions, you could definitely throw them in the chat. We'll talk about it, whatever you want to know as I'm going through. And I do have to give you a disclaimer that although I'm an attorney, doesn't mean that I'm your attorney unless you hire me. So you should know that as well. I have to basically say that because for some reason they think that if I don't say that, you're going to think I'm your lawyer. So just so you know. And everything I'm saying today is for information only, right? Yeah, it happens too often, is right. So what I'm saying is for information only, but basically I want you guys to kind of understand what having an estate plan is, what building a legacy is about. I'm going to talk about some basics, like what are some of the tools that we use to kind of help you protect your legacy. And it's not a one size fits all. We can kind of tailor things to meet what the needs are of, the people. And what I typically do when people come to me is I say, fill out this questionnaire so that we know everything about, what's going on in your life. And then we try to come up with a plan for you rather than just trying to make it cookie cutter for everybody, because it's, everything is not for everybody. And some things that we don't necessarily like, that are not our favorite types of estate planning things to do, it might be what's good for somebody, right? So what is an estate plan? Because it sounds just like what does that really mean? So an estate plan is basically, or I should say your estate is basically everything that you own that's of value, right? So typically when we think about somebody's estate, it may be their cash, whatever they have in a bank account. It may be their real estate, if they have any real estate, if they, have a stock portfolio, if they, if they own a business, that's part of your estate plan. So anything that is of value that will continue to, build and grow value, that is something that you can pass on to somebody else. That's part of your estate. And sometimes we don't think that things are valuable. I know I met a lot of people who had, property that was in their family, but because they didn't want to deal with tenants or they didn't want to deal with, having to keep up, a property, they, kind of just let it go. Like I had met a family that I was trying to sell their property when I was doing purchase and sales. I was trying to sell their property, and because they couldn't come to an agreement, they didn't trust each other. Everybody thought everybody was shady, and they weren't trying to sign over. They weren't trying to come together to basically sell the property. So they end up losing the property to property taxes. Literally, nobody could make up their mind. They would have each gotten a couple thousand, over 20,000 a piece, and it was five of them. And they just, let it go to taxes. So I also want you guys to know what's valuable. There are things that are part of your family that could be valuable, and that if you look at it the right way, you could use it to build for tomorrow. So another thing that estate planning does for you, it helps you save on taxes. So if you if you plan ahead of time, you can avoid having to pay taxes. Right now, the estate tax is kind of high. So if you die basically and you have more than $11 million right now, your family doesn't have to pay taxes on that money, but it's supposed to go back down to 5 million. So I know that, our culture, social media, a lot of people are putting out information teaching us how to invest, how to, build wealth. And you could easily, if you're following any of these, any of this advice, you could easily build over $5 million worth of wealth. And then if you're married and your spouse has money, or you come together, you could easily have over $5 million. Or if you leave money to your children and they have money, they could easily have over $5 million. And my point is that you don't just want that money to go to the government, right? Because they're just going to take it. All the money that you worked hard for, all the wealth that you built, they're really just going to take it. And so part of estate planning is to make sure that you don't have all that money going to the government, everything that you built your wealth for. That's what the rich folks do. They make sure that their money stays in the family. They make sure that they use all the tools that the government allows you to do to avoid paying tax, right? Not tax evasion, but avoid it. Exactly. So what are some of the things that we use? So I'll start with the basic things that you want to have in place and why they're important. Sorry, I was getting a call. So the basic things that you want to use. So power of attorney is something that's really important. It is basically a document, it's a piece of paper, but it allows you to give somebody else the rights to make decisions for you financially. So what happens is, if something were to happen to you and you, God forbid, were in the hospital, or you were stuck out of the country, or whatever the case may be, that you couldn't actually get to take care of your financial affairs. Most of the time it's somebody sick or somebody got hurt and they can't do that. What happens to all of your stuff? So if you have a business, what happens to your business? If you have children, if either you're with your spouse or you're not with your spouse, what happens to all of your bank accounts, your bills, if you have bills, or maybe you have income streams that you need to actively be doing something in order to keep those income streams going. And so if you had excuse me, if you had a power of attorney, it would allow you to give somebody else the right to do that. So what some of us don't know is that even if you're married, your spouse can't necessarily go to the bank account and deal with your financial affairs if they're not on that account, or if you haven't given them the right to do so. So you can find somebody who you trust. You're not giving away your rights to handle your finances, but you can have somebody who you trust to have this as a backup plan. And you don't even have to give it to them right away, but you can have like a system in place. Like, okay, if something happens to me, you could let somebody know that this is where everything is, and that way somebody will have access to take care of your business, basically. So your business, your personal life, but it's a power of attorney. And I've come across a lot of situations, because a lot of times people want to come at the last minute and they're like, oh my God, I need a power of attorney tomorrow. I need so I'll give you some examples. So I had one situation where a good client of mine, their parent just got ill out of nowhere. Like, he was the breadwinner. He just got ill out of nowhere, and then was like in the hospital, like basically incoherent. And so because of that, it was a while. And so because of that, they couldn't pay the bills. They couldn't, do anything, because they couldn't access the account. And they're like, I need a power of attorney. And I'm like, well, we can't do a power of attorney now, because the problem with that is you got to have your full capacity. So what that means is that the person has to have, on all their mental faculties to be able to know right from wrong and know the impact of them signing a power of attorney. So that's why you can't wait till the last minute, till, grandma can't make decisions, or dad can't make decisions, or your spouse can't make decisions, to say, oh my God, now I got to go to the hospital. And just imagine, all these people who have dealt with these COVID situations, who didn't have any plan, because nobody expected anything like this, right? And so it's funny how we always buy insurance for our cars, we buy insurance for our homes or whatever, but we don't put anything in place in case something happens to us. We think it's optional. And I just want to encourage you that it's not optional. It's something that you should do to plan to avoid a lot of pain for your family. Don't wait till the last minute. So that's the type of situations that we have where people don't get power of attorneys in place. And another story that I could share with you is that a young lady had told me that her and her family were in the process of selling their home, and the father, I think he fell into a coma, or he had a stroke. He had a stroke and he was not, coherent. So he was not able to actually sign a power of attorney. And they wanted to sell the house. They needed to sell the house for financial reasons. But because they just didn't have anything in place, they could not complete the transaction. So that was like a super unfortunate situation. And then if the father passes away, now they have to go through the court system, have the court assign somebody, to give somebody letters of administration, to be able to actually, transfer the asset properly. So that could be months later, where now you're not selling that property anymore, or you're not selling it right now. You're gonna, be waiting and be held up because of that. So that's power of attorney, right? So that's one of the things that is important. Another thing is a healthcare proxy, and a healthcare proxy is basically it's another document that says, if I'm in the hospital and I can't, make decisions for myself, that this person can make these decisions for me. I have another situation where a family member, not my family member, but a family member of a client was in the hospital, and they needed to have a certain type of treatment, but the family member was not, that they weren't in their right mind, but the family could not determine that they were in their right mind, right? They needed the doctor to say that he wasn't in his right mind, but because they know that this was not like him, he would not have made this type of decision, because that's not who he is. So if you had a healthcare proxy that says, this person can make decisions for me if I'm not in my right mind, and whoever it is that you want to be able to determine, it could be a doctor, but it could also be a family member that you say, I know that I know this person is emotionally stable. I know this person could make these decisions for me if something were to happen, and therefore I want to be able to give them the right to do that. And in that situation, even the spouse couldn't make the decisions for them, because that's just how the law is written. You cannot make decisions for somebody else unless they actually write and give you the power to do so. If anybody has questions, feel free. You guys could put them up and jump in. So I am paying attention. And then so the next thing that is kind of common with trust and estates, which you all probably know, is a will. Right? Everybody knows a will or have heard of it, but rarely do people have a will. And even if they do have a will, a lot of times people are not even telling anybody that they have a will. They're keeping it so secretive and tight to the chest that it's hard for anybody to even know what's going on. And so it makes it very difficult for your family to even, one, be able to get your assets, and two, to know what exactly that you wanted to be done with it. I had a friend of mine whose his uncle passed away, and his uncle was very close to him, like a father, and he knows that his uncle had a will. I would say he kind of assumed, but he was pretty confident that his uncle had a will. But because there was no instructions left in place, nobody could, find it out. They were not able to locate it. And it turns out that the uncle's property ended up going to an estranged son, where he had a nephew, and he had two nephews that he actually treated as his children. They know that he would have wanted to leave something to them, but it ended up going to an estranged son or child. So the moral of the story with that is that you get to decide, right? You get to decide, and maybe a lot of people on here are not older, or maybe old enough. I shouldn't say old enough, but maybe they're not in their advanced age, right, of a certain age. But you have family members, that may be, and it's not about being old. It's about having a plan. It's about being prepared. So you should definitely, start thinking about these things. Not that you have to, act right away, but you should definitely start thinking about this. So he said, Johnny says, do you need a will if you have a trust or a living trust? So you don't need a will if you have a trust or a living trust, but I'll say that with caution, because if you have small children, you may want to you should have a will, because you want to be able to plan for them. You would need to appoint someone to be a guardian, unless your spouse is surviving. But if something happens to you and your spouse, you want to be able to have somebody to be in charge of those young children. So make sure that if you do have young children, you should have a will to kind of at least cover that. Another thing is, when we do trust, we tend to do a pour over will as well, because the pour over will would then transfer anything you got outside of that you got after you created your trust. It would then pour it into your trust, right? It's sort of like, if you think of it as figuratively, anything else that happened after I created this trust, now this will catch it and then pour it into the trust, right? So that's what happens. Because somebody like Nipsey Hussle, he didn't have a will or anything, but he got most of his wealth when he got older. I'm sorry, he got most of his wealth like shortly before he died. And so even if he did have one, it may not have been up to date like the day before he died because he was 33 years old. And so if he had a trust, but then he had a pour over will, everything else that he got, during those last few years would then be poured into the trust. So it's something good to have hand in hand. We always do them hand in hand. But I typically don't like just doing a will, because a will would force your family to have to go to court, especially for people who have assets in various states, usually real estate. So if you have real estate in, Georgia, in Michigan, in Philly, in New York, then your family will have to go to every single state and probate, which basically means go to the court to try to get those properties. And so to avoid that, a good strategy would be to transfer everything to the trust, right? Or to have a pour over will that pours everything into the trust, so that now when eventually, God forbid, when you do pass away, your family doesn't have to do all of that, because the titles are held in one place and the courts don't have to be involved. Let me see, I missed some questions here. How do we build a trust to get these things in order? We're not communicating. How do you build trust? Okay, I see what you're saying. So how do you build trust between you and your family members? I think it's just about education. It's hard because some of us are stubborn. I know. I have family too. We're stubborn. Our culture, at least the older generations, tend to be a little stuck in their ways. But I think starting with education, starting with conversation to talk about it is a good way. Like I've had people call me, like young people, like, yeah, I'm trying to convince my mom or my parent or my grandparent or whatever to do this thing or to think about this thing. But I say don't give up, just have the conversation and talk to them about the things that could happen. This is also like a stigma in our community. Like if you start planning, then you're like basically, asking to die, or you're causing yourself to have to die. But it's not about that. It's about, I will come from the angle of talking about, you worked so hard all your life to get what you have, whether it be a little or a lot. You can give the next generation a leg up or a couple steps up where they don't have to now start from scratch. Like, don't you want to not let everything that you've done, go in vain? And I think that's a good way, because then you're showing them what they're losing. They didn't work so hard to give, or we didn't work so hard to give all of our stuff to America, whatever, the federal government. You work so hard so that the next generation could do better. And collectively, we need to do better as a people, because we see what's happening. We're going to be extinct in a minute. You know what I mean? So we want to make sure that we are doing that. And another thing is, I heard a statistic, and I forget the timeline, but I heard a statistic that, Black or African Americans net worth is going to be zero in like a couple of years. And I mean, I'm, God willing, that's changing, because I do see a lot of, wealthy people, especially young people, coming up. And so, hopefully that's changing with us sharing information. But, you could talk about it like that. Facts and statistics don't hurt, Okay, would a living will include things about custody of your child in the event something happens? Yeah, I actually had that conversation. I mean, I had a client who was asking me about that as well. It's not a living will. A living will is also another document, but a living will kind of is similar to a healthcare proxy, and it kind of gives more detail about healthcare treatment. So I won't really go into it that much, but I get what you're saying. You're saying, should a will include things about custody? It should, because if you have custody of your child and the other parent doesn't have custody rights at all, meaning they were deemed to be an unfit parent, which is what happened in Nipsey Hussle's case, then you want to definitely have stuff in your will about custody and who you want your child to be with. Now, the living parent can try to challenge that. They can try to challenge it and say, well, I'm the living parent, then I should be, the person who gets to parent the child. And that's what happened in Nipsey Hussle's case as well. But they determined that the parent was still unfit, at least at the moment. So the family, his family was able to maintain custody of the child. So you should at least have your wishes put in place so that could hold some weight. And it'll be, it would more lend a hand to the judge to lean towards the person who you chose. But that parent, the other parent, does have the right to kind of try to exercise their rights on that. I hope that answers that. Let me see. Trust is what we should use. Told me not to. All right, so you said, I'll talk about trust next, but someone said not to name their daughter, not to name a guardian for their daughter because the courts will decide. You don't want to leave anything to the courts. First of all, family law and estate law leaves a lot of discretion to the courts. So that means that the judges have a lot of leeway in the law. Like, it doesn't hold them to like really tight rules. And so because of that, they can make emotional decisions, very likely. They're humans. So I wouldn't leave anything gray. I would make your request known. And as long as your request is known, that's like as much as you can do. Now, like I said, if the court decides that, the other parent, the surviving parent, is the person that should have the child, then they're going to decide that. But at least you make your request known, and you give the guardian a chance, because probably that guardian is not going to have any rights otherwise. So that's the only way that you're going to kind of make it known what you wanted if you put it in your will. So a trust now. So a trust is also a document. So a lot of times people ask me, like, what exactly is a trust? Like, how does it function? It's similar to how we know like a business entity is, like an LLC. It's not an LLC, don't get confused, but it's sort of like that. It's like fictitious. It's like a thing, right? So it could just live in your drawer basically because it's a piece of paper that we draft. But a trust gives you much more flexibility. A trust basically allows you to say whatever it is that you want to be done with your estate. You can decide that you want your child or your family or your cousin or your best friend, whatever, to be the heir of your asset. And you can even do it over time. Like, you could say, like for instance, Whitney Houston, when she passed away, she had left her daughter. She did it in a will, which I don't think was the smartest thing to do. But in any event, it kind of works somewhat for her purposes. She stated that she wanted to give her daughter 10% at the age of 21. Then she wanted to give her another 10%. And she had like a $14 million estate. So the other thing is she drafted it like 2 months before her daughter was born. So she really should have updated it. And had she put it in a trust, she would have been able to help control it and manage it a bit more for her daughter. But in any event, she gave her 10% at 21, and then at 25 she was going to get another 10% if she would have survived. But she didn't account for her, dying early, so it ended up going to her mom. But I say that to say that you can kind of design a trust, however you want it. There's a lot of flexibility with it. You avoid having to go to court, so your family doesn't have to go to court, or your loved ones don't have to go to court, and it's a little bit more tax efficient for them. So there's a lot of reasons why it's better to do a trust, but I don't say that blanketly, because there are certain reasons why it may not work for certain people. Maybe financially it doesn't work, or maybe it doesn't fit their goals. There are some differences. So someone said, so having a trust prevents the probate process. Yes, it does prevent the probate process. It prevents you from having to go to court. It's a lot easier for your family to kind of just, pick up and run with what you have already decided. And they don't need a judge to tell them. They don't have to pay for estate tax. No, I'm sorry, not estate tax. They don't have to pay the court for the probate fees. And they don't have to pay legal fees because everything is already done. So it's a much easier process, especially when if you have family members that are like fighting, or that somebody, I spoke to somebody today and they're like, oh, I got 5 kids and I know they're going to fight over my estate. And so when you have situations like that, you can avoid a lot of friction when you have a trust. And you just have to pick somebody as so when you do a trust, if you're the person who's drafting the trust, you are considered the grantor or the creator of the trust. And then the person who is going to be running the trust, like making the day-to-day decisions, taking care of the assets, is the trustee. In certain situations, you can be the trustee as well. If you want to do an irrevocable trust, which you cannot change, essentially, let's just say you cannot change it. There are ways, but generally you cannot change it. You cannot be the trustee. So that means you have to appoint somebody to make the day-to-day decisions of the trust, whether they buy and sell assets, whether they, invest, whether they give money away or whatever it is. If they start a charity, whatever, you can do that in a trust, and you can give your trustee the rights or the power to actually do that. See if I missed any questions. Yeah, so it gives you a lot of flexibility, and that's what's really attractive about it. The difference between the reason why you would do a revocable trust, which is the trust that you could change, is if you're kind of young, if you're still building your portfolio, whatever assets that you have, if you're still growing your business, you may want to do a revocable trust because you can change it and you have more flexibility. However, you can also, if there are certain assets that you're sure about that you want to set in place, or you're sure about how you want them to be treated, you can do an irrevocable trust and start to fund it. We call it funding when you put stuff in it, essentially, and start to fund it a little bit over time. So you could certainly, do both. It just depends basically on your situation, on, when and why you would do one or the other. Someone said, if you're married and have no kids yet, you can make your spouse a trustee. Yeah, you can certainly make your spouse, you can always make your spouse a trustee, even if you do have kids. It just, when you get to the age where you may need Medicaid or Medicare, so if you need like long-term care, if you're going to need like a nurse, or if you're going to need someone to come to the house, or if you're going to need to stay in a facility, you want to start thinking at that time about an irrevocable trust. Now, you don't want to wait till that time, because there's a 5-year period where the basically where Medicare, where the government can look back to see what assets did you transfer. So people used to be able to do that. Okay, I'll check the box. People used to be able to do that, and what happens is they got hip to it and was like, okay, y'all think y'all cute, you transferring all your assets, and then you try to get Medicare so the government can take care of you. So you kind of have to plan it ahead of time to be able to, preserve your assets and also take advantage of, the government's assistance, which that's also what the wealthy do. They transfer their assets out, and then the government takes care of them. Unless they're super wealthy and they really could just afford it, and it doesn't matter how much money they spend, they'll still have. Okay. Okay, so these two questions are about asset protection. One said, any tips when filing an LLC individually? So Maximilian, can you be more specific what you mean about that? I am going to be talking about business tomorrow, so I can get more, into it a bit more. I'll be on at 6 tomorrow. And what type of asset protection do you offer? So my firm focuses on, we do trust and estates, which can help you protect your assets. So if you are looking to protect your real estate assets, your stocks, your cash, we'll come up with a strategy to kind of help you do so through using maybe some trust and estates tools. Maybe we'll use some business entity tools to kind of preserve your interests. And if you have, so for instance, I have a situation where this young lady came to me. She owned property with her parent, and she got into a car accident and she got a DUI, right? And they were actually suing her, but it was a couple of years later, like 4 or 5 years later, they were suing her, and she was afraid that they were going to come after the house. And so we had to kind of think about what are her options. She actually came to me to say that she wanted to do a reverse mortgage. And I was like, no, do not do a reverse mortgage. I don't know if you guys have come across this, but I do not like reverse mortgages. To me, it's a way for basically banks to come in and take our wealth away, right? They do prey on older people. They'll say, you know what, you don't have to pay your mortgage for the rest of your life. You could just live here for free. And then when you pass away, we'll just take the house. It's a terrible idea. Typically, what they do is the interest kind of runs, it's a much higher interest, and it runs much faster than it would if they were literally just, if they took out a line of credit and tried to do it that way. It does not make any sense. Please don't do reverse mortgages. But in any event, she came to me and she said, she wanted to do a reverse mortgage. She feels like she had no choice. Another lawyer actually referred her to the mortgage person to do a reverse mortgage. He told her that's her only option. And so we actually decided to transfer it to an LLC. The reason being, and that's risky too, because the fact that you know that you're in a lawsuit and you transfer the property could be a situation where they can consider it a fraudulent transfer, right? So it's not illegal to transfer the property, but if they look back, they could say, maybe you try to do this because you were getting sued. But we came up with a strategy for her. Another thing is, even if it's in the LLC, it's a good chance that they may not find it. She did not own it alone. It wasn't really hers. She was really buying it for herself she was really helping her mom to get the property, so it wasn't really hers. So anyways, and we put some other stuff in place. So that's kind of like what we do. We try to figure out how to help you save whatever you have and how to help you, transfer it properly, prolong it, make sure you're in the best tax position for you. And so maybe that may be something like a deed transfer, that may be something like a trust, a will, or a business entity formation. We also do trademarks, which is helping you to acquire the asset, right? And then make sure once you have it that you are keeping it, you're using it right, and you're protecting it as well. That's what we do. Yeah, so someone said, Heavenly Neek, suppose both parents pass and children are under 18 years. How should the parents choose a guardian? So you should choose somebody that you trust, like literally somebody that you trust to leave your children with. That something to know about that is that you can have more than one guardian. So legally, there's a guardian of the person and there's a guardian of the assets or the finances. So you could leave somebody to be in charge of them, physically, like, take care of them, make sure they go to school, that type of thing, raise them. And then you could have somebody who's in charge of the assets. So maybe somebody who's really good with money, maybe they're in finance, maybe you trust them, or maybe you want to choose like a professional to be in charge of their assets. And then you want to choose somebody else who's just like, a good caring person that you would trust to raise your child. You could leave them as the guardian of the child. The guardian of the person is what they call it. So those are two different ways. But I mean, it's a hard thing to do, to choose who you're going to have your children raised by when you're not there. But it's something that you should do because, God forbid it happens. You don't want your child to be an orphan or to be with somebody who you would not have chosen at all. That's something that would kill me. So I totally understand that question. Thank you, Max, for waiting till tomorrow. Can assets in an LLC be placed in a trust? Yes. You can do it in one of two ways. Actually, a trust can create an LLC and an LLC can settle the trust. So both ways. You can have a trust in your LLC. You can have an LLC in your trust. That is one of the things that we try to do to help our clients kind of protect their assets, depending on the situation. But it is a strategy that you could use. If someone is looking to build if they want to have a holding company and have a series of companies underneath it, you may want to consider starting with a trust. There may be reasons to do that. It's like you have your built-in estate plan with it. And so it helps you to not have to now go out and do another plan. And it also helps you to save on taxes and a whole host of a whole host of other things. But yes, you can do that. Yes, both sides of the family may fight over the children. Yeah, if that's the case, you definitely want to. If both parents were not around, whatever the parents say, is the thing that's going to basically hold weight. That's where the children will go. Should a married couple, okay, Heavenly Neek with the questions. I'll take it. Is it true that a married couple should get separate wills? If so, why? Won't they contradict each other? So the reason for that is if they have previous children, or if they have previous, really the most weighted reason is if they have children outside of the marriage. Because if and then we're talking about having two separate wills or two separate trust plans. If one passes away and their stuff is left to the other spouse within the will, right? Then what's to say that that spouse is not going to then change the plan after you have passed away to exclude your children, right? So that's one of the reasons why I typically do it, is because if you have children outside the marriage or the relationship, you don't want someone, once you pass away, to now go back and change that plan, because they're the only one alive. They can just, change the whole game, and now what you had wanted for your children is not what's going to happen, right? So that's one of the major reasons why you want, and they shouldn't contradict each other. We call them mirror. They're not really mirrored. They're going to be slightly different, and we draft them so that they don't contradict each other. Are you able to do trust? Hey, Mr. Clark. Are you able to do trust wills in any state or only New York and New Jersey? Yeah, so for right now, I can only do them in New York and New Jersey. This information that I'm giving you is kind of general. Like, you can apply it to where you are. There may be some slight nuances in the law, but for me, what my company does is New York and New Jersey. I am thinking about expanding, but that's just a thought for right now. So don't hold me to it. What if you also have a business outside the country? If you have a business outside of the country, now we get into trying to figure out how do we balance our laws with their laws, and what they're going to recognize versus what basically what that country's going to recognize versus what you have here. A lot of countries have treaties. So if there is a law in place that says that they are going to honor, the will that you have drafted in the United States, then that will be something that we could that would be effective over there. So we could include that business in there. Typically, I like to speak to an attorney from there, or kind of get more information about the local laws, and that would usually, require me to speak to an attorney so that I know what exactly we can do or can't do, or what the limitations are. Okay, I have an LLC property. I have an LLC in a property. I think okay, can I place that LLC in a trust so that my wife can get the property? She's not a part of my LLC. Yes, you certainly could do that. You can transfer your interest from the LLC, your membership interest, to the trust. So it would the company now would be named in the trust, or the trust will own that portion of the company. Or you could do it upon your passing. You can have that in your LLC documents that you want your interest to go to your trust, and then the trust would then pass it to your wife. So either way, is something that can be done. How would you put in trust here in the USA? How would you put in trust here, Stefanat? If you can, sorry if I butchered your name. If you could maybe explain what you mean so I could help you. Come to Georgia. I know. I'm thinking about it. I'm actually working on to see what the process is. So if they let me in easy, I'll do it. But I'm not taking another bar. Sorry. So you have a YouTube channel where you cover these times. So I do have a YouTube channel. I just started it though, so don't go expecting thousands of videos. So I'm just trying to get it beefed up with some content before I start promoting it. But I have a YouTube channel. I'll probably put this video up there so that I can start sharing more information with you guys, because it's really part of who I am and what I like to do. Although I'm giving away free game, it's okay because I know that it's helping people, and I really want you guys to, soar. So whatever I could do to help, yes. Thank you for asking. It's my name on Instagram, Sabine the Purpose Lawyer. Okay. All right, I'll check my DM. Build my own version of LegalZoom. That's actually a great idea. Black-owned LegalZoom. All right, I'm gonna think about that. We do need our own. That's true. That is true. Group economics. If y'all help me, I'll do it, okay? If I currently have an LLC and set up a corporation in the future, can I transfer my current LLC under my corporation? I'll answer it. It's a business question, which I'll talk more about tomorrow. But can you transfer your LLC to your corporation? Yeah. So if you're basically trying to structure where you have a parent company and you want your LLC to be a sub company, you could certainly transfer it. We'll do that, with paperwork, basically documentation. Also depends on the state. Some states we may need to amend some of your filings. So it just depends. How often should you update a will or trust? You should think about updating at least once a year. You may not need updates once a year, but you want to look at it and make sure there are no major things that happened in your life that would change your circumstances or change what you decided that you wanted to do with it. So definitely take a look once a year to kind of just make sure that things are okay. And if they're not, and you want to change things, have that conversation. If you're in my jurisdiction, I'm happy to have that conversation with you. All right, so some of the things that I think we kind of talked about everything, but what I wanted to kind of stress is education. If you have assets that you want to leave to a loved one, you need to start preparing that person to know what to do with it, right? You do not want to now give somebody property or assets that they're going to lose. That's why we see a lot of these neighborhoods that we grew up in or live in. We see that they become sort of like run down. People are not taking care of the properties. They're not taking care of the land. They're not, they're letting things go into foreclosure because nobody taught them. You can't stay tight-lipped. Your children should know exactly what's going on. Like I talk to my daughter all the time about financial literacy. She's 7. A lot of times she rolls her eyes. She has no idea what I'm talking about. But as time goes on, she's going to start to really understand, and it's going to sort of like be ingrained. So if it could be your nephew, your cousin, your friend, whoever you plan on being the extension of your legacy, then you need to speak about it. You need to talk, have conversations, be comfortable about talking about money, about death, about planning. It's natural. It happens. Just make sure that you are not just giving somebody something for them to blow up, really, really take the time or provide resources. That's what I really just have to say. So I have a real estate attorney in Maryland or Ohio. Oh, all right. I'm trying to work on giving you guys referrals because a lot of people ask me and I really want to put that together. So I'm working on it. I don't have one. Do I have one for Maryland? You know what? Send me a DM. If we have one, then I can transfer. I could give you that information. All right. I think we might have had someone for those states. If you become a millionaire or very well off, how do you recommend dividing your assets among your children? At what age should you release money to them? Oh, that's a difficult one. It's really going to be personal, right? So some children might be better off than others. If you know who they are, unless they're literally babies, if you know who they are, if they're adults, and some are better off than others, you may want to provide more for one than the other. If somebody's more responsible than the other, you may want to be a little bit tighter with your funds, or maybe give it to them over time if they're not that responsible. You know what I mean? I would think you want to do it equally, but I know all families are not the same and everybody doesn't have the same relationship. So that's going to be a personal decision for you. How should you release the money to them? You could decide to do it over time. There are different ways. We could have, a longer conversation about that. But typically, if it's somebody who's young, you want to give it to them in increments. Maybe you want to put some rules in place that they have to achieve a certain thing, or they have to use it for a certain reason, or whatever the case is, so that that it's not just going to go to waste, and that they're going to be able to handle it when they get it. Somebody's going to be salty. Exactly. We hear that all the time. And that's a lot of times why people don't want to talk about their estate plan. They don't want to, because they don't want drama while they're alive. They rather everybody else deal with the drama. So, yeah, somebody's going to be saltier, for real. Between the topics you discussed, which do you feel is most important to have? Will, health, trust. All right, so if you say you are somebody who's just like, I just want to have something in place. I can't do, a complete plan. I just want to have something in place. I say bare minimum, power of attorney, healthcare proxy, and then a will, if you could do that. But ideally, I would like a trust to be part of that equation. Okay. Depending on what you have, but most likely. And that's it. Let me see if there's any more questions in here. Heavenly Neek, DM me about that lawyer that you asked me for. Yes, that is all for me tonight, guys. Thank you so much for joining me, for being interactive, for asking questions. I appreciate you. Again, all this was for information only. Don't be like Sabine gave me my estate plan and now I'm ready to rock and roll. That's not it. So make sure that I just want you guys to start thinking about this stuff. Even if you're not ready, at least and you start putting it in your mind to be able to do it. Don't wait too long, because we don't know, tomorrow's not promised. Let me just see. I got 2 more questions. Do you still go through probate court, or does it depend on the state? If you have a will, you usually will go through you usually will have to go through probate court if like real estate is involved, or if there is assets to be transferred that requires a title of some sort. Okay. A few years ago, should I do so percussions massage. So you said you acquired assets after you did a will a few years ago. Should you do a new will or trust or pour over? Possibly. Most likely you're going to need to. I would, if I were you, look at your will or have an attorney look at your will. If you're in my jurisdiction, I'll be happy to do it, to see if there needs to be a change, or if your will already covers it. Likely you may want to have a trust depending on what you have. If you have a business or anything like that, you may want to consider doing a trust. But yeah, it should be looked at for sure, 100%. All right, you guys. Thank you so much. Love you. I appreciate you. And I'll see you guys tomorrow. I'll be back talking about business. Bring all your business questions. And good night. Bye.